Hello, welcome to this, the first education team webinar in this brave new world of remote video conferencing. Thank you all very much for agreeing to join us today. I'm Fiona Scolding and I am leading the session today, which is all about the Public Examinations 2020, or as Leon said, how to operate a rescue mission out of what otherwise would be a total disaster. We're here to talk a bit about the proposals that Ofqual are going to make some observations about where we think the challenges may come and whether or not they may or may not succeed. I'm joined today by two of my colleagues. Jesse Vanderman unfortunately can't be with us this afternoon, but I'm joined by Samantha Broadfoot, Queen's Counsel, and by Leon Glenister. And here we are. There's lovely pictures of us all up now. Sam's going to talk to us first about examinations. Sam has a lot of experience in undertaking education law work, and she's worked in particular, she's done a lot of work for the government over the years on various issues around this. Leon as well, many of you know, has done a lot of education work and in particular has expertise about the sort of interface between the school and the university system, which is obviously very relevant for some of the issues which arise today. So I've got a few housekeeping matters which I have to look at. Everyone's microphones are automatically muted, so nobody needs to adjust their local settings, whatever that is. I'm still coming to grips with this sort of thing. We would welcome questions throughout the session. The idea is going to be that we will speak briefly for about 5-10 minutes each, and then we will answer a series of questions, some of which have been sent in advance and some of which we hope you will send us on the day. We can't promise we will know all the answers, but we have tried to have a think about what the major issues might be. Please, at the bottom of your screen or at the top of your screen, there should be something saying Q&A. Please do send your questions in. We will try and answer all the questions by the end of the presentation. If we haven't had a chance to do so, we will follow up with those after the event. If you lose connection at any point during the webinar, we invite you to rejoin just by clicking the link. So there's no need to talk about either fire safety or toilets, which are the usual things that occupy the first couple of minutes of those. So without further ado, I'd like to pass over to Samantha Broadfoot, who is going to give us a little bit of an introduction to how this came about and Ofqual's broad thinking in respect of how the marking is going to happen this year. Sam.
Hello, hi, thank you Fiona, thank you to everyone who's tuned in. So my name's Sam Broadfoot and I'm going to kick off this session by setting out in brief outline where we've got to with the process for determining grades, given that the public examinations have been cancelled. Now, I have a close personal as well as a professional interest in this issue. I have 3 teenagers at home, one of whom was due to sit A-levels and another who was due to sit GCSEs. So I'm acutely aware of the impact the uncertainty has had and is having on the children, on the parents, and of course also on the school teachers, school centre and other institution teachers. And what the schools and other centres have to do is, and have been asked to do, is no easy task. So in the next 5 minutes or so, I'm going to set out the basic framework upon which Leon and Fiona will then build on certain aspects in a little more detail, and then we'll endeavour to answer any questions. So the key dates, just starting first of all. So the guidance was obviously issued a couple of weeks ago on the 3rd of April. That left quite a lot of questions, and then last week we had the Equalities Impact Assessment, and the consultation was published. Now the consultation is a fairly hefty document, and I will touch on some of the aspects there. The important date to note though is that the consultation closes next Wednesday on the 29th of April. So any observations that want to be made by you, whether you're schools, whether you are representing people, or indeed any parents or anybody else who may have tuned in, next Wednesday is the deadline. And then the next important date is the 29th of May, which has been declared to be the earliest date for centres to provide the grade, rank and declaration, which we'll look at shortly. And then although there was the prospect of an early results day in July, that has since been moved back to August. So as I understand it, the two results days remain the same, the first one for A-levels and the next one for GCSEs. And then of course we may have the autumn exam series in September or October. I don't think that date's been finally set. The key requirements under the guidance is that schools, colleges and other exam centres must provide three things. Firstly, an assessed grade per subject per student. Secondly, the rank order of students within each grade. And thirdly, a declaration from the head of centre. Turning briefly to those, an assessed grade must be the grade that the student would most likely have achieved had they sat their exams and completed any non-exam assessment. And the key takeaway point about all of this is that it's supposed to be a holistic assessment. So it should be based on a range of sources, including classword, mocks, and previous examination results. For example, any resitting students or those with relevant AS qualifications. The consultation recognises that this is quite a difficult task, and both the consultation and the guidance recognises that where, for example, you've got a number of different teachers teaching the same subject, let's say English or maths, that there will have to be quite a level of coordination across the teachers to try and work out how to grade students when not every teacher will know every student. In terms of rank order, that is the second piece of information that is required. So the school or the centre must provide the rank order of students within each grade for each subject. So for example, if you have 37 students sitting maths, you have to, and you think that 12 of them will get a 7, then you have to rank those 12 within the grade of 7. So it's not just a question of, although it comes, I suppose it amounts to the same thing, but it's the same as going from 1 down through to 37, but you've specifically got to rank them within that band. The final thing then is the head's declaration. This has been expanded upon and explained a bit better in the consultation. And in essence, it puts a responsibility on the head to be able to say, I am sufficiently aware of the information upon which this is based, and I verify that this is an accurate, that these grades and estimates are accurate. So which qualifications do the guidance apply to? It applies to GCSEs, AS and A-levels, EPQs, which are the extended project qualifications, and advanced extension awards. Now, I thought that was originally only in maths, but it's now made clear that it should be in any subject where that applies. There are going to be a separate consultations, or one consultation, regarding the list of other types of qualifications for which Ofqual is also responsible, namely Cambridge Pre-U, International Baccalaureate and others. But Ofqual is not responsible for international GCSEs, and so none of this guidance applies to those. I suspect, but I haven't looked up yet, that there will be separate arrangements for them. Which year groups? Some of you may remember that there was quite a lot of response to the initial guidance, which said it would only apply to students in year 11 and above, i.e. those sitting, basically those sitting GCSEs early in year 10 or even below were not going to be graded. And the logic for that was that it shouldn't normally prevent students from progressing in their education, because they could then sit the exam the following year. But in fact, as a result of a lot of correspondence, the proposal has now changed. And so the position is that actually everybody who was due to sit an exam at that this summer will be entitled to have an assessed grade as well. Then finally, as I mentioned at the beginning, there is this consultation. In one sense, it is quite, it's a very detailed and carefully thought out document. It tries very hard to explain why it has made and is proposing the compromises that it is proposing. But there are gaps in it, and there are issues that will arise, which we'll go into a little bit later on. And so whatever thoughts you may have or concerns you may have about it, use this opportunity to respond, because certainly on past evidence between the guidance and the consultation, Ofqual has moved on its views on certain aspects, so it could well make a difference. Thank you.
Per usual, I'm the one who forgets to unmute myself. Thank you very much, Sam. That was very helpful. Now passing over to Leon, who's going to talk to us about the excitement that is appeals and also the super excitement of algorithms.
Thank you, Fiona. Yeah, so one thing that's come up quite a lot in the conversations I've had with interested people, and indeed the questions we've received this week, is generally the concept of fairness. So I thought I'd tease that out slightly in looking at two particular aspects that are interrelated: the appeal system and the algorithm, which is the standardization process. Now, having read the guidance, what's quite interesting to me was that there is no suggestion that this is going to be a process that is as good as everyone taking the exams. And I think everyone, even Ofqual, accept this is sort of the best of the bad situation, or making the best of a bad situation. And I should say, Fiona credited me with the definition. This seems like a rescue mission by the government. That was not my words; those were the words of David Atkinson, who's the head of Dr. Challenge. So I'll give credit there, but I think it's a very apt description of what is happening. There are, we are all working at home, and people are saying Zoom meetings are really good. Actually, these are in many ways better than face-to-face meetings. So will those continue in the future? I don't think anyone is suggesting that next year this system might be replicated. This is definitely a second best, which tries to do the best it can in the circumstances. Now, looking at the appeals first, how the sufficiency of the appeals to a large extent depends on the importance of the grade that you're given under the calculation this summer. And there's a bit of ambiguity about that. So the initial guidance that was issued by Ofqual on the 3rd of April said, used the term both grades will stand. That's been tempered slightly in the recent consultation, where it suggested that students can elect one or the other, but it's going to be subject to further consultation, this particular point. That's what is clear. But it appears to be looking at the practical effects, like giving students individual exam certificates for each subject, so you don't have a certificate with one lesser grade in English that you're not relying on and one better grade in maths, which you are relying on. So it's looking at the practical situation. But there are other practical issues here, because, for example, in my understanding, I think general practice is that resits generally should be put on UCAS, and they form part of the declaration you put at the end as to providing all the information. So in that respect, you may need to, on your UCAS form, put both grades. And while there's no certainty about the UCAS procedure this year or next year, some people with these A levels will be applying in either October or January, where they will probably be relying on the calculated grades. The grades do have some importance to individual students. And those grades are to be calculated to a very large extent on professional judgment of teachers, over which students have very little control, certainly at this point. And one way to resolve that potential tension is to have an appeal system. So let's look at the appeal system. Appeals usually are fairly straightforward because you have an exam script, and the exam script can be remarked on an appeal, and if there's coursework, it's often that can be marked by a colleague in the school. So you have sort of one piece of evidence which people can form views on. But that won't work here because it's professional judgments of teachers. We're in a bit of a different situation. And the current proposal is that there will be no appeals of the professional judgment of the school. So no student can appeal what the school has said is the grade or the rank. So that's the current proposal. Is that fair? Well, think of a student who may just not get along with a teacher and they're not taught by any other teacher in that subject. Well, obviously they're disadvantaged. And is that a fair mechanism? I'll leave that as an open question at this stage. Then we look at what if a student doesn't agree with the procedure that's been adopted by the institution. It's not an individualized problem, the procedure by the school that's been adopted. Again, there is no appeal mechanism in relation to that. And that's partly a practical reality situation because that whole process would have to happen before the grades are issued. So you'd essentially need some intervening period after the ranks and the grades have been submitted to then have some kind of appeal mechanism. It won't work. So that's more understandable. And there's no appeal in relation to the standardization model, which I'll come on to in a few moments. The only proposed appeal that the government is suggesting is where an exam centre, so a school, can appeal on the basis of the procedure adopted by the exam board. And it's things like there's been an obvious error in the data that's been submitted or some other kind of procedural error. So it's very limited, the appeal rights. And it's more limited than the situation in other years, because in other years, although it's procedural, the exam board will look at whether the marking criteria has been fairly applied in any particular case. If there's quite sort of an appeal through a remark because you're looking at the exam script, obviously that won't happen here. And that is all consistent with what information is available to students. So the guidance says that to stop teachers potentially being persuaded by students of trying to give them a better mark, the data in relation to rank and grade will not be passed to students. Completely understandable. The students will only get that data if they make a subject access request under data protection legislation. But that legislation provides that a school doesn't need to give that data until 40 days after the exam results have been published. So in any appeal, they're unlikely to have the data anyway, and they can only get it later on down the line. The only way I can see that my provisional view, I'm really interested in comment on this, my provisional view on this, the only way to deal with this problem, but there's such a limited appeal right, where there is such a high degree of professional judgment being exercised, the only way to do that is through having an option for students when they get their calculated grade to take the exam in November. And we had a discussion before this, we kept calling it a retake. It's not a retake, just to take the exam in the autumn and then take that grade instead. And that seems to me to be the only or an option in this situation.
I think it's very difficult because there are, as far as this issue is concerned, the courts are going to be very reluctant to get involved in anything which looks like professional judgment. And so any challenge, I think, would be likely to fail if you were to say, I'm going to judicially review the school because I think they've acted unprofessionally in respect of my child, or the child hasn't got on with the teacher. And I think the courts would be very reluctant to get involved in any kind of entertaining any of those sorts of claims at all. Do you two agree?
Yes, I completely agree. I don't think the court's going to get involved in a judicial review. Neither do I think the schools or the court's going to entertain that if claims are brought against the school by students, which is another method. You can either judicially review the system or have individual claims. I don't think the court's going to entertain that in either event.
Okay. Yeah, I think I would agree with that.
Yeah. So I'll briefly deal with the standardisation process. Now, so what happens, the grades submitted, then there's this standardisation process which brings the grades in line with each other. That's the idea. And it's obvious that that is needed to iron out any differences between schools' standards. Now, looking at the model that's currently been proposed, it is that the greatest weight is to be given to what a school has achieved in the past, and then using the rank to try and match what's happened in previous years. And so there'll be a greater emphasis on the rank rather than the predicted grade. Now, that model, and that's what the consultation suggests, that model is open to consultation, but there's two issues with that, or at least two issues. One is that there is likely to be it will not cater for, a good year or a bad year. So it will disadvantage the student who so happens to be in a very good cohort in a school. And the second thing, if you get a student who is, for example, the best student the school's had in the last 10 years, they will be prejudiced by this situation. So one question will be, what does that student do? Can that student make some kind of challenge or appeal to how the standardization algorithm has applied to them? And the answer, in short, is no. so that, I think, is an issue with the standardization problem. For the moment, it was quite interesting, actually, is I think there is an argument, and this is open for debate amongst others, is there's a very good book called Hello World by Hannah Fry, and she looks at different algorithms and how, for example, in the US for bail applications, actually algorithms are better at predicting a criminal reoffending than judges, and how that fits in. And she goes through all these examples, and actually her conclusion at the end is what algorithms are good for is to improve fairness, but what you always need a human override on it to iron out any sort of anomalies in the data. And I think one option here is potentially to have some kind of input from the school, just to tell the exam board, actually, this student is the best student we've had for several years, or this cohort's very good, just so the exam board knows and can take that into account in the model, because at the moment that doesn't allow itself. So those are my thoughts at the moment on the fairness angle, and I'll hand it over to Fiona, who will continue.
Thank you very much. Thank you, Leon. I just need to click. I'm going to talk a little bit about calculated grades and the consultation in and of itself, as well as some issues about discrimination. So, right. The first issue is one of bias, whether conscious and unconscious, in the way that the exams are going to be assessed this year in comparison to normal. Now, the consultation is absolutely clear that it recognises that there is a risk of bias. It describes it as largely a risk of unconscious bias with the way that teachers will assess children. It seems to me that the position that Ofqual finds itself in is to recognise that there are problems, but to basically say this system is largely no better or no worse than the systemic issues that there are within the exam system generally. And in fact, what the research shows, and they've done a brief literature review, which if anybody's particularly interested in, is very helpful, which basically says there isn't that much research on this area. What research there is in the UK in large studies tends to be from UCAS about predicting A-level grades, which in fact suggests that there is an over-prediction of grades for Black and ethnic minority students. And the most accurate forms of prediction are for, in effect, students from a higher socioeconomic class and students at independent schools. So interestingly, the bias seems, in fact, some of the research seems to suggest that the bias works in the other way when it comes to teacher assessment. What in effect has been set out, because they have undertaken a separate equality impact assessment, is to identify that there is the distinct possibility, particularly in respect of private students, who I'll come on to talk about, i.e. students who haven't been attending a school setting, who are more likely to have protected characteristics, either because they're from traveller families, so they're going to be attending a number of different schools, or they're going to have arrived in the country recently, so there may well be issues around discrimination on the ground of their nationality or ethnicity, or there will be issues because there are a significantly greater proportion of pupils who have a disability or who would be considered to have a disability who will be educated at home. And for those students, it's not at all clear what's going to happen, if anything, in respect of their exams this summer. What is interesting, particularly in respect of gender, is the limited research that there's been done. And one of the difficulties is, particularly in the UK, teacher assessment has never been part and parcel of an exam process. It has to a certain extent in respect of coursework, but there hasn't been a lot of analysis and research about the way that teachers approach assessment, particularly not in this context. But the little that there has been seems to suggest that gender plays a reasonably small part, with, interestingly, boys being overestimated for English and underestimated for maths, and girls being vice versa. So, I mean, what's interesting is that Ofqual are clearly grappling with that. They obviously have a public sector equality duty, but what they're really saying is that for both schools and for them, what they're probably hoping to do is to do no more than replicate the inequalities which we know already exist within the exam system, and trying not to perpetuate any more, because as they recognise, there are distinctions between, for example, the outcomes for black children, white working class boys, that we all know about. So as far as schools are concerned, the advice that Ofqual gives, which I think is probably the only advice they can give, is they need to pay attention to those equalities issues when they're undertaking assessments for pupils with disabilities or with special educational needs who are likely to be considered to have a protected characteristic of disability. You should be looking very carefully to make sure that the work that you are assessing is being assessed clearly and fairly, because there is some evidence in the literature that children with SEN are undermarked in comparison to the results they ultimately get in exams. And obviously you will have to take into account all work bearing in mind the reasonable adjustments that may already have been taken into account. As far as other pupils are concerned, I think it's a case of thinking about those issues and looking at them. What has happened is there was some discussion, and there is discussion within the consultation document, about whether or not the standardisation process should in effect pull up children or remark them on the basis of their ethnicity or socioeconomic class. And Ofqual has decided not to do that. It has said that it will look at issues of race, gender, class, usually by the proxy of free school meals, and disability in the deep technical data, is what they say, is in the deep technical issues. I'm not quite sure, but I think that means embedded into the algorithm is going to be something which is going to try and take account of those things when one's talking about standardising grades. But other than that, they have reached the decision. It's obviously out for consultation, but what they've said is at the moment, they're not proposing in effect to alter the marks significantly to sort of, for example, to identify like a greater weighting if you happen to come from a black or ethnic minority background or from a white working class background. They're not proposing to do that, because what they're saying is that, that would in effect be trying to gerrymander the system too far. So I think what schools have got to do is just be alive to the issues of the fact that equality impact, they've got to think about the various inequalities that might arise within their school setting and make sure that those inequalities are no more or no less than they would be in any event within the context of the examination system. So that may well be particularly relevant when you're looking at what work should you look at, how should you carry out that holistic assessment, are you doing so on a fair playing field, if necessary, making sure that reasonable adjustments are being made, particularly for those with disabilities. Homeschooling. Now, this is a small problem, but a significant one for a number of children. That 1.3 million candidates are entered for exams, and in fact they sit some 5.5 million exams every year. I mean, it's just an extraordinary number of examinations. Of those, 20,000 are what's called private candidates, i.e. they won't have had teaching via distance learning or via any form of school setting. So they are largely pupils who've been educated by private tutors or have been educated at home by their parents. At the moment, the proposal is, it's out for consultation, but what they're saying is that unless an exam centre can sign you off, and they're saying they're working with some exam centres to see whether or not, in effect, you could put work in between now and the end of May, but unless you can do that to the satisfaction that the exam centre feels able to sign off on your grade, it's unlikely that you will get a grade for this year. Now, I know from practical experience that a number of further education colleges and universities are saying to home educated students, don't worry, we'll take you, even if you can't get a grade for this time around, because they're being pragmatic about the situation. At the moment, there isn't any answer to this question that Ofqual are giving us. Ofqual recognise, for the reasons I've already given, that this is more likely to be the case with those who've got disabilities, or more likely to be the case for those who have particular religious views, which often mean that they should be educated at home. The answer appears to be, well, they can take the exam in November, but that doesn't really help if they're moving on to apprenticeships or to university or to other matters where it has a material difference. I think given the small number of candidates that we're talking about, I suspect there may well be quite a sort of Benthamite approach to this, which is we're willing to sacrifice the few in order to satisfy the many. But if anybody has any good suggestions as to how practically you could carry out this assessment without having a head of centre, I'm sure Ofqual will be interested in finding out about it. So the reality is, as we've already identified, there are a number of, I suppose, possible public law challenges which could be brought, none of which we think would necessarily succeed. So the first issue is that what happens if the school's general approach to grade or ranking calculation is flawed? Now, I can see circumstances in which the flaw would be so magnificently bad that an institution could be considered to have acted sort of in respect of malpractice almost. But firstly, the exam board would probably take that up because it has separate responsibilities to make sure that exam centres are operating things properly. So I think the courts would say, well, have you gone to the exam centre, have you gone to Ofqual, have you gone to the exam boards about what you say are these fundamental flaws in the way that the ranking's taken place. Secondly, you would expect the exam boards to pick that up when the grades come in, because they can obviously ask for the evidence, and so therefore you would be assuming that they would be looking at that. Thirdly, I think it's highly unlikely that the courts, as I've already said, will want to interfere with anything that looks like I got an A and I should have got an A star. The courts have been very reluctant to intervene in those sorts of disputes when they've been run largely to do with higher education institutions. I can't see it would be any different. I think the court's answer in most of those cases would be to say, we're terribly sorry, but you can sit the exams in November. There isn't proposed to be an appeal in the current in the current appeal process for students. Again, there are reasons given within the consultation for that, but we would want to, I think again, the rationale set out in the consultation is quite powerful as to why individual students shouldn't have particular, shouldn't have particular grades. There are also obvious issues to do with the fact that the relevant information isn't going to be available to students or parents about how the assessment's been reached until really it's too late, until the grade's been given. Firstly, because the underlying grade and ranking won't be available until afterwards. But secondly, because the algorithm is unlikely to be published, which could be the other element or angle of any challenge, would be to say the algorithm's fundamentally flawed for the following 10 reasons, because that's only likely to be published just before all the exam centres go in. So there will be issues to do with timing to do with that. So as far as schools are concerned, I think some schools will come under very heavy pressure from parents, and we'll come on to that when we talk about the practical things which could be done in the questions, particularly what schools are taking into account and how they're taking them into account, because there really is no guidance currently given about prescribing, you have to take this into account, you have to take that into account, which I think we're going to deal with, and which a number of you have got some questions, particularly about the timing of the information that should be taken into account. But the other issue is the autumn series. There seems to be an automatic assumption that by the autumn everything will be okay, but I'm not sure it will be. The reality is that they're not going to be able to run these exams remotely. There are too many candidates, there are too many people, there are too many issues to do with either rigging the system or the system crashing or socioeconomic disadvantage. But it may well be that by October or November, we're not in a position, even under social distancing, whereby you can resit those exams. There's also the issue of trying to sit a set of exams when you might not have been at school for 6 months, and when your motivation, shall we say, to work hard may well have dissipated entirely when you were told on the 23rd of March that you wouldn't be sitting your exams. So, I mean, let's be realistic about 16 and 18-year-olds' desire to do another set of exams in November, and how much they are or aren't going to do that, and how much the disruption to the teaching, both the back end of last term, this term and next term, would impact upon their ability to be successful in any exams in the autumn in any event. We're now turning on to the Q&A, and we've had lots of questions coming in. I think the first question we wanted to focus on is the evidence. A number of people have asked us questions about what evidence should they be using, and in particular, whether or not they should be using work which was commissioned after the 20th of March. Sam and Leon, do you have any views about that?
Thanks, Fiona. The issue about evidence that was generated or commissioned after the 20th of March is quite a tricky one. The guidance says that the school or centre's judgments should be made on the evidence that is available. And of course, that guidance was issued on the 3rd of April. So they're clearly looking backwards over the course of the previous 1.5 years for the purpose of the assessment. Not only is there no requirement to set additional mock exams or homework for the purposes of determining the assessed grade, but in fact, schools are urged to treat such new work with caution. And it says that where additional work has been completed after schools and colleges were closed on the 20th of March, heads of centre should exercise caution where that evidence suggests a change in performance. Now that's really very tricky, isn't it? I think that partly the purpose of that exhortation was in recognition that people will have very different domestic setups. And so where you have perhaps a large cohort from a variety of socioeconomic classes, and some of them will have access to a space in which to continue to work and others will not, then I think that the caution really is in effectively downgrading somebody on the back of not having done some work. Equally, you can't really test in an objective way, evident material that is produced after the 20th of March, because of course you haven't seen them. So you can't test anyone in exam settings very easily. And so somebody who then suddenly performs extremely well, that should also raise alarm bells. So I have a personal interest in this question because my kids' school has set my A-level and GCSE students a whole host of things to be doing, and including now threatening them with further mock exams at the beginning of May. And obviously, my advice to my kids is, well, you'll just have to get on and do with it. But the reality is that, you know, people are saying, oh, well, they'll be cheating and it's all very unfair, etc., etc. So I think the bottom line is that maybe schools could use some later evidence, maybe to help them possibly refine the ranking perhaps, but it is very difficult, and I think they should exercise great caution in relying too much on that post 20th March evidence. What do you think, Leon?
Yes, I completely agree. I think, yes, caution just needs to be exercised. The guidance clearly permits it, but caution's against it, as you say, so I agree with what you said.
On the other hand, I think this is the difficulty, because what Ofqual have said, and I don't think they've got the time to do it, is they've said we're not going to set any strict guidance about timings or about what you can use, because there will be such a vast variety of different methods by which children are assessed prior to the public examinations. So if you allow that variety, you could also say, well, we know that there is often a push, so children work harder over the Easter holidays and the summer term. Now, quite how much in the context of a pandemic, one could really say that the usual rules apply. Some parents I can see would say that, and therefore it's not fair, because although, you know, for example, my daughter will not do a stitch of work until she absolutely has to, she would then pull it out the bag. So I think you're going to have competing pressures. But I tend to agree with Leon and Sam. I think it's best to err on the side of caution to the material which you know can be produced without taint, so to speak. But I mean, there are all sorts of ways. I mean, if you're teaching children by Zoom or by remote learning and you were doing orals or something like that, that's not really cheatable. One of the other issues that a lot of people have raised is about autumn exams and whether or not schools and colleges have to run them or whether they're going to be optional only. Well, the answer to that question is they haven't said as yet. At the moment, they're still considering whether or not they can make the exam boards run them, because they don't, because I think what they're saying at the moment is they can't necessarily compel them to run the exams in the autumn. The likelihood is they will run the exams in the autumn. And my view is that you would be, if they do run them, I think most schools and colleges would be well advised to put them on. I think saying we are not going to run them, you would run a risk of a discontented parent bringing a claim against you, because you have to think about what's procedurally fair. Sam and Leon, do you agree with me as far as that's concerned?
Yes, I mean, what linked to that, I've seen a question recently, I think might have been on LinkedIn actually in response to an article, but asking what happens where a child was due to sit their GCSEs this summer at a school that stops at year 11, and the child was then due to go on to a sixth form college to do their A-levels or other qualifications. Whose responsibility is it to enter the child for the autumn session of exams? Is it the school from which they came, or is it the college to which they are going? And again, there's no answer to that at the moment, because in fact, hasn't even decided whether or not the exams are going to mandate that the exam boards run exams, or whether it's going to just make it optional. So I think these things are some details that are going to have to be ironed out.
But I think if they're going to mandate them to happen, it would have to be from the school which you would have taken them in the summer. Because in a way, as we've already said, you're not resitting, you're sitting for the first time. So it would make no sense, because the idea behind the autumn exams is to allow people who would have sat them in the summer another chance. so to speak, to try and remedy any unfairness there might be, I think that would have to come from the school. And schools usually allow a certain number of pupils to resit. The difficulty is that if you've got the entire year resitting, the administrative burden of that, of trying to reorganise the timetable to take account of loads of people being in a gym, particularly when you may well have had everyone out of school for a 3 to 6 month period. You know, administratively, that's a nightmare.
And the cost.
And the cost.
And the cost, because all the exams cost money. It's a bit unclear what's going to happen in relation to the costs.
Yeah.
Whether
Well,
it's being refunded.
Yeah, that would relate. I mean, that kind of situation happens, and this is one of the other questions we've had about year 14 students. So students who have left after sixth form and then are coming back to retake. It's a similar situation. The school often takes responsibility for doing that. And the question in relation to that was, what if those students are being taught other than at the school with tutors, and how do we then try and put them into our rank, and can we? And I think the answer to that is it's a case by case basis, and whether you feel you have enough, or the school feels it has enough information to viably assess them, the student, on their assessment and their rank in light of what they know from the year. And it may be, the one thing I would say is be consistent about it. So have some kind of policy or some kind of general rule as to who you are going to permit. It may be that certain providers, or if they've done it, if they're, those students have been being taught by certain people, then you may say that that's sufficient, or others not. So, but have some kind of general rule which you follow for all the students. Any other views on that?
No, I don't think so. We've had another question about Equality Act claims. If you wanted to bring an Equality Act claim, could you bring one against the school in the first tier tribunal? I don't think you could, because, well, I think it would very much depend on the facts. The reality is that your challenge would be to the grade as awarded or as assessed, which is a challenge against a qualifications authority. So it would be a challenge against the exam board. It may well be based upon the fact that the school had failed to do various things. But I think the reality is that that would be a challenge against the exam board, in which case that goes to the county court rather than to the first tier tribunal. Do you agree, Leon, or have I got that completely wrong?
Yes, I think that's right. There's an issue about the mechanism by which a school's rank gets inputted into the grade. So actually challenging the school's input on its own will not actually amend the grade. It's one of the key inputs, but there's a bit of so there's that issue. But I agree, if it's I think I haven't checked it, but I think the Equality Act says it's claims against schools that go to the first tier tribunal rather than
and I think even if it was the school that messed up, the overall claim is against the grade awarded, isn't it? The grade
exactly,
awarded, not awarded. So it would be, the claim would be against the examination board or Ofqual as the public sector regulator, depending on the nature of the claim. And there are specific, the Equality Act sets out, has got specific provision for bringing claims of discrimination against examination boards. We've got a question about, are there any circumstances in which Ofqual can change, or a examination board can change the school's rank order? Now, my understanding is, Sam and Leon, I'm passing over to you here, but my understanding is they can, well, they may well change the rank order because
they can't change the rank order. They can only change the grade. I think that's fairly clear from the guidance. They can't change the rank order.
Somebody said, what practical tips you might have for schools to ensure that internal notes they have on predictions ranking ensure they stay on the right side of the line, i.e. are framed as much as possible in terms of teachers' professional expertise? Is it a case of less is more, or should schools make detailed notes justifying each and every rank? Well, I'm going to give a classic barrister example here, which is, I think it's context is all. I think you as a school, I think you need to be able to show what you've used when coming to your assessment, both about rank and grade, And that needs to be clear and as transparent as possible, because although there's going to be a delay in the timing of any subject access request, parents and children will be able to look at them. So I think it's got to be something which is clear to understand, is transparent, is based upon some kind of internal policy which is applied consistently, but which allows of exceptions where exceptions are required. Because the one thing you can say about this situation is there is unlikely to be a one size that fits all. And so therefore there may well be some subjects where you would want to take one approach and other subjects where you would want to take another approach. Does anybody have anything else they want to add? Otherwise, I wanted to throw something out, which is about how practically a teacher's going to do this. Now, I know some of them are in school, but lots of them aren't in school. How are they going to physically get access to the material? How are they going to bring it all together? How is that going to be done in a socially distanced way? I think there are lots of practical things, because the ideal would be the department, everyone in the department that was teaching a GCSE or an A-level would sit down and say, right, okay, how are we going to do this? How is this going to work? And although we can all do that via Zoom, I think maybe, obviously teachers are much better at screen sharing because they've had years of whiteboard. But I mean, there's all sorts of practical issues about the fact that this is all going to have to be done by the end of May. Is it practically feasible to suggest that a fairly sophisticated and nuanced system of assessment is going to be able to be worked out by then? Sam?
I think, no, do you want to go, Sam?
Sam first.
I was going to say, I think what's interesting is that there has been no guidance on how schools should be doing the rank system, and that's been justified to quite a large degree in the consultation document by saying that that schools will have their own materials and their own procedures, and in terms of the IT issues and distancing, schools will have their own IT systems, some of which will be set up better for remote marking than others. And I think that's fully justified, but I do think that the Department for Education could have issued something just to say this is good practice, because I think schools themselves will be talking to each other. And I think it's a good thing, if you are a school trying to figure out how to deal with this, is just to sense check what you're doing against other schools. If you're in a groups of head teachers, for example, just have a conversation, because I know those conversations are going on at university level at the moment to try and coordinate. And one of the sort of endorsements that were other universities are doing similar things to us. So I think from that respect, in terms of how practically to do it, including all those IT issues, I think the first thing is, as you say, get detailed notes, but also have those conversations with other schools to check that they are doing a similar thing to you, that you're not completely outside the realms of what's going on.
The other thing I would say about universities is I don't think there has been any unified view that's come out of Universities UK or universities generally, and they're all playing their cards very close to their chest. Off the record, it looks as if the expectation is universities always over-offer. The expectation is that because they're likely to lose a significant number of international students for next year, the likelihood is that they will in effect honour everyone who meets their grades, even if that means they go over the number they would usually have. But there is, at the moment, that seems to be a view, whether or not that's the view that then crystallises, but that they accept that they're likely to be going over number, possibly significantly, because universities always do at least 120% over, and some universities in fact offer double the number of places on the basis that people won't make the grades. So I think the expectation in a number of universities is that they're going to have bigger cohorts of UK students, but possibly much smaller cohorts of international students, which financially is a significant problem for them. But on the other hand, if you've got children sitting grades this year, sitting exams this year, that might be some comfort to you. But watch this space, because none of them are really saying anything openly, but behind closed doors, that seems to be the discussion which is happening. Right, I think we've probably got time for one more question. Right. Right, What happens if someone's been expelled for a short amount of time in an education centre before the lockdown? Will the predicted grade be based on the short time that they've been in the PRU, or will it be based on the time that they've spent in school? Well, I think I can answer that. If you're entered for your exam on the 21st of February, so it depends where you were on the 21st of February as to where the centre is that you will be sitting, that you would have been sitting your exam. So if you were excluded after the 21st of February, you would still be technically aligned to the centre where you were before you were excluded. If it was after the 21st of February, there is sometimes a system for late registration in effect. What the consultation says about this is late registration, we're going to have to see what the evidence is. If there's good evidence that you would have sat the exam in the summer, we're going to take that into account. The reality is that it's a proper centre would take into account both the work that happened before the child was expelled and any work which has happened pre-20th of March, but post that child being in a PRU or another educational centre. I think that's what fairly should happen, but it might be a bit of a stretch to try and get people to accept that. Leon, Sam, do you have anything you want to add about that?
No, I mean, the guidance does recognise that it does recognise the cut-off date in February, as you say, and does also make an allowance for some sort of late entries, although they've said that that will be up to the individual exam boards, I think. The difficulty is who has to sign off the declaration. And I would have thought, though, that certainly my instinct would be that if a child was in a PRU for the last 2 months or 3 months, having been expelled, then actually they ought to work together with the school to give the best assessment of grade that they can. And the person who signs the declaration will presumably do so on the back of, the other information that they have about the work that was previously done. That would be my thought, because otherwise you are really disadvantaging, or rather even further disadvantaging, a child who will already be disadvantaged by the fact that they've been expelled. Yeah.
And I mean, the other factor is that I think, Sam, you and I have spoken about, is the fact that none of these grades are on any performance tables. So the Secretary of State has said that none of this is going to count. So therefore, one of the issues that's often worried about is off-rolling. So students being kind of engineered expulsion to make sure that the grades are kept up. None of that is relevant this year. So that it may well be that there's a much more benevolent approach taken by centres to those children who've been excluded. And obviously we know that year 10 and year 11 there's usually the largest number of exclusions, particularly for boys.
Yeah.
Right. Well, it's now 5:30. I think we could probably go and probably answer one more question just for another couple of minutes. Although I'm sure Nishi or Josh, who are co-hosting this, will tell me if that's wrong. There is a question from someone which says, can I sue the school for the ranking that they give my child? Sam, Leon.
I mean, it's going to be very difficult, isn't it? Because the first point is you're not going to know it. And you're not going to know it for quite a long time, if indeed you ever know it. And I think this perhaps, there's a proposal in the consultation that they create an exemption under data protection to prevent the ranking from, and indeed the underlying judgment from being disclosed for a very long time, I think. Actually, Leon, you're probably more on top of that aspect of it.
Yeah, so it's 40 days after the exam period, after the exam results are released. That's when the school has to give it. So you can make a subject access request now, and then even today, or once the data exists, so in a month or so, or a month or two, and then the school won't have to give it till 40 days after the results.
So
that takes you to the end of September, basically.
I mean, let's assume that you've got two ends of the spectrum. You've got a ranking that you disagree with, but it'd be I think it'd be incredibly difficult to sue the school over it. If you think that the ranking has been provoked, your child has been unfairly very lowly ranked because there's the teacher, the relevant teacher, loathes your child for whatever reason, there's a personality clash, then you've got to ask yourself on a practical level, how on earth would you ever begin to prove it? And the whole system is set up to protect as far as possible the school's integrity and the professional integrity of the professional judgments that are going to be made. So I can see that being a very, very difficult challenge. I mean, whether as a matter of law one could ever sue if it was negligent or done in bad faith or whatever it may be is perhaps a different question, but on a practical level it'd be very difficult to see how you might get that off the ground.
I mean, unless you've got really good examples of clear bad faith, such as would kind of amount almost to a sort of like a misconduct type behaviour, I think it would be very difficult. Now, obviously, technically, you can sue a school if they don't teach you adequately, but obviously that involves it being demonstrated that the teacher has fallen below the standard of a reasonably competent professional in the manner and the form at which they've taught. And to be honest with you, very few of those cases ever succeed, because it's often very difficult to show that even if the teaching has not been great, that would have made any difference to the grade that somebody would or wouldn't have got in any event. And certainly the courts have been very reluctant. They set the bar quite high in terms of, even though it is what is reasonably competent, in a way, they set the bar quite low as to what competence is in that context. So there have been very few claims which have succeeded, certainly in the past 15 years, in respect of sort of suing schools for teaching badly, in effect, unless you've got...
Sorry, what is your loss? I mean, because, exactly. I mean, you could, there would be a loss potentially, but you would presumably be expected to mitigate it by sitting the autumn exam session. So you can see how, you know, it would be difficult, A, evidentially, and then B, then there'd be the cost benefit analysis would probably also be quite tricky, because you'd be expected presumably to sit it in autumn.
I think the only issue might be for certain independent schools or for certain sort of crammer colleges, I can imagine, where if you can show that there's been a representation made that, you know, we will get your child from a C to an A or something like that. I mean, you'd have to be extremely foolish to make those sorts of representations. But if those sorts of representations have been made, you can see those sorts of cases being run. But that's really got nothing to do with the exam grade. That's more to do with foolish promises which should never have been made in the first place, which could be counted to be part and parcel of an implied term and condition of the contract in the context of the independent school sector.
I think just one thing to add is that there's sort of two angles potentially to the question. So what the practical situation you'll end up with is at the end of September, as I've said, you will then find out your rank and then you'll be unhappy. So what do you do about it? There is the way your ideal situation is that you want to change the rank, so then you will get the grade you want, but that won't be possible because you will have to argue that the rank is unlawful and therefore in legal terms it will be quashed. So the rank goes, but then what that will do is it will affect everyone else in the cohort. So the court is never going to touch it. So I think the practical reality is you're never going to be able to change the rank so that you get the grade. The only possibility is, as Sam and Fiona have been saying, is to bring some kind of negligence claim to get money from the school, but for the reason they've given, that's going to be almost impossible.
Yeah, because, and what the consultation makes absolutely clear is that they're going to be very reluctant to entertain any kind of appeal which is going to involve the whole cohort going up and down, although I think they're kind of saying maybe sort of if there's an absolute disaster zone or something in terms of ranking, so that, you know, the process has completely failed at the exam centre, but you would hope that that isn't the case. I mean, what a lot of people have been saying positively is actually it's likely to mean that the results are more generous overall. And what people have also said is if it works, or if it works as well as the exam system, that some teachers who are fans of teacher assessment have said that this might be the start of Britain moving away from the kind of written exam culture, what one might call the Cummings-Gove approach to exams, and a move back towards more teacher assessment and to trusting the teaching profession a bit more. I don't know whether that's the case or not, but I've read some articles which are certainly quite positive about this as a process.
Great.
Great. Well, thank you all very much. Thank you all for your questions. Thank you all very much for providing us with so many questions. I'm sure that there are other questions which we haven't answered. We will do our best to try and answer those questions or those issues in the follow-up. You will get a recording of this, as I understand it, at some point tomorrow. And then I think within the next week or so, we'll try and put together a document which seems to sort of an FAQs type document for those issues which we haven't been able to go through within these timescales. But I wanted to thank you all very much. Thank you again for putting up with certainly my technological incompetence, which isn't shared by my co-presenters. And please feel free to contact all or any of us if you've got any questions or concerns. But thank you very much for joining us today. Goodbye.
Goodbye.